Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case that deals with the powers that the judges have for contempt of court, and more importantly, the limits on those powers that prevent them, in theory, from being abused or misused. So this is an appeal decision. It's out of the Court of Appeal for the Northwest Territories, and it is the case of the King and Bryce Burroughs. This one's also got some really interesting facts. We get to see some back and forth between the judge and Mr. Burroughs in court, and we can sort of get into this dispute here. So this one starts off with Mr. Burroughs appeals his conviction for contempt of court. We agree the conviction cannot stand. Spoilers, I actually think that this is the preferable way of writing decisions. I don't like the will they, won't they that some judges or some appellate courts like to do. I think they should put the decision at the front and then explain why. And that's exactly what they do here. So the background facts are straightforward. At the commencement of the trial of a friend of the appellant, the friend's trial counsel advised the trial judge, "Good morning, Your Honor. I'm here with my client, Mr. Rainer Erasmus. We are in most respects prepared to proceed to trial. There is a witness, and that was Mr. Burroughs, who is in custody at, and it's a correctional facility there. I did obtain a removal order last week for his attendance. He was present on the last court date. He is apparently not coming to court today." Now, not coming to court today is not usually optional. When the counsel indicates that they have a removal order, well, that's because if you didn't take those steps to get that order, the court would just say, okay, you didn't get the order, so no deal. Usually, you're going to subpoena witnesses. You're going to make sure that they're present using all of those tools. It's usually not optional, that you get to decide whether you want to go to court. The court is clear about that as they say, well, that's not his choice. I direct Madam Clerk to notify the correctional center to extract him from his cell and bring him here. And the lawyer says, "Thank you, Your Honor." Later in the morning, the trial judge advised counsel, Ms. Malone, before you begin, I can update you. Court staff or registry staff advised me that the correctional center was refusing to comply with the removal order. I advised they better send someone over here because if they refuse to comply, someone will be held in contempt of court. Now, the judge shouldn't be saying this at this point. First of all, it's not great to threaten people in general, but you can't necessarily promise that someone's going to be held in contempt before you've heard the reasons. Maybe they say, hey, listen, we can't comply with the order because we've got a riot down here and we can't even get in there without the tactical team, so we can't get him. Like, it's a riot. Sorry. You just don't know. There might be a medical emergency. There might be all sorts of things that are going on. You can't say we're going to hold someone in contempt of court until you know if it's actually contemptuous. All right. When Mr. Burroughs was called in the case for the defense, he appeared, was sworn, and testified. So he did eventually testify. At the completion of cross-examination, the following exchange occurred. And this is kind of funny. So the court questions the witness. "Mr. Burroughs, I understand, sir, you refused to come to court this morning." Answer, "Yeah." Court, "Why?" "I had an exam to take this afternoon, which I missed, so..." And the court says, "When did you get out of jail?" Now, I'm just going to note that exam will be for some sort of rehabilitative program. Quite possibly he's trying to get like his high school, diploma in jail or something else like that will help, help him gain skills to maybe stay out of trouble in future. So those exams are important because if you miss one, you may end up losing the whole class. That's a reason why you might not want to be dragged out. And certainly a witness who had an issue with, an exam or something like that, they might have otherwise applied for an adjournment, but we don't necessarily tend to give the same courtesies to people who are in custody. So yeah, the court then asks, "When do you get out of jail?" "I don't know, probably October." Court, "Would you like another 90 days? And the answer is, if you want to slap it on, go ahead. So this guy's just not having this. He's not, He's not bullied. He's just going, all right, if that's what you feel like doing, go for it. Court says, well, I tell you now, and you tell your buddies over at the pen, if you do not come to court when you're required, you will get 90 days tacked onto your sentence. Now, you can't just impose a flat sentence for this because there might be mitigating reasons. There might be aggravating reasons. Each sentence has to be individualized. You can't just create a policy like that. Answer, that's fine with me, man. Court, all right, well then he says, the last thing I need is a lecture from you. The court says, you can have an extra 90 days. Okay, that's fine, no worries. Court says, take him out under section 708 sub 2. He says, it's already time served anyways. So there's a little bit of back and forth there, but there's a whole bunch of things wrong with this exchange. And the court's going to get into that. We'll cover it, so let's have a look. The above exchange illustrates that the appellant, Mr. Burles there, did not have counsel, nor was the Crown given an opportunity to participate. Because the Crown did not participate, the Crown was permitted to appear as amicus on the appeal. So this just means that they were able to assist the court. So the law is clear. A court has authority to summarily deal with contempt. So that means sort of bypassing a lot of the typical trial processes and so forth. However, before the court proceeds summarily, the circumstances must make it urgent and imperative to act immediately to convict and sentence a party for contempt of court, understanding that the use of a court's contempt power should be restrained by the principle that only the least possible power adequate to end the contempt should be used. If a court uses the summary procedure, and in the absence of exceptional circumstances, natural justice requires that 1. The party be cited for contempt, in that the party be advised they must show cause why they should not be found in contempt. So they have to give an opportunity to respond to this, right? To say, here's why I shouldn't be held in contempt, and to make those arguments. And, Mr. Burles didn't seem to have been given that chance. The party be given an opportunity to be advised by counsel. So they should have found this guy a lawyer if they want to hold him in contempt. It's a courthouse. It's usually not hard to find a lawyer who's willing to step in these kinds of ways, but it doesn't look like that was tried. And if they choose to be represented by counsel, and 3, if the party is found in contempt, the party must have an opportunity to make submissions as to an appropriate sentence. They need to be able to argue, like 90 days is too much, too little. It can't just be declared by fiat. So, quoting from a previous decision, a number of safeguards to prevent a misuse of criminal contempt powers exist. The alleged contemnor is entitled to fair notice of the alleged contempt, time to answer the allegations with the assistance of counsel, absent the need for immediate action because of their disruptive conduct. So if you've got somebody who's in the courtroom and they're shouting and they just, they won't let the proceedings go, then contempt might be allowed. You might be able to use that power to remove them immediately or something like that. And a fair and public hearing where they enjoy the typical protections afforded any accused person, including the right to silence, the right to non-compellability. So these 2 rights are important, right? You've got a right not to be compelled to provide evidence against you, and you've got the right to not say anything. When the judge starts questioning this guy who's still up on the stand about, hey, why didn't you show up? He should have been warned that he's got the right not to answer those questions, because that wasn't part of that trial. That was, in fact, an investigation into contempt. And so that's a point where he should, enjoy those protections. The right to make full answer in defense. So to bring your own submissions, to bring your own evidence. The right to be tried by an independent and impartial tribunal. Does this judge feel like he was sitting as an independent and impartial tribunal? I've got some questions on that. And to be presumed innocent until proven guilty beyond a reasonable doubt. So the court here goes on to say, there are a number of concerning elements in this case. The process followed by the trial judge was inquisitorial about past facts. and the facts he relied upon were based on multiple forms of hearsay. The judge was relying on having heard these out of court statements. That's hearsay. And the judge can't act as a witness, as it's got to be, a standard court process. The conscriptive inquiry by the trial judge denied the witness a right to choose whether to speak. And they compare this with another Supreme Court decision. The approach followed was inconsistent with the entitlement of the appellant to have allegations of misconduct explained to him, and once familiarized with the allegations, to choose to have the misconduct proven against him. So this sort of follows the ordinary process of a trial where the judge says, listen, there'd be an allegation put to him. I think you didn't show up for good reasons. And the accused should be able to say, okay, prove it. At that point, there should be an actual trial process for that. It is not open to a trial judge to impose a guilty plea for contempt upon a witness who is merely reticent about coming to court. Here, the appellant was offering some sort of explanation when his ability to do so was interrupted by the trial judge. Further, it is not open to a trial judge to truncate the opportunity of the witness to explain the alleged contempt, or to purge the alleged contempt, or to argue the alleged contempt was purged, or to speak in mitigation of the alleged contempt. As the appellant attended court and did in fact give evidence in the trial of his friend, there was a live issue whether the contempt, if it happened, was purged. The trial judge short-circuited all of that. So what do they mean when they say purge the alleged contempt? Well, let's say the court says you need to bring these documents to the trial. That's part of the subpoena. You are subpoenaed not just to come on your own, but also to bring certain essential documents that are needed for the trial. And you decide not to. And the trial judge says, why did you decide not to? And you say, didn't feel like it. There's, 3 boxes. They were heavy. I just thought, nah. The judge might then cite you in contempt, and the next court date, you might have had some time to think about this. And you might say, you know what? Maybe I ought to have done the thing. So on the next court date, you bring the documents in. This might be an argument that you have now purged the contempt because now you're following the orders, right? And now you're doing your best to follow those things. Similarly, if there's, in a family law case, there's a court order that says you must provide the other side with visitation. Well, if somebody isn't providing visitation, that might be contempt, but they might start again and thereby purge the contempt. There's all sorts of ways this can happen, including sometimes just making an apology. An apology can sometimes do it. So what we saw in that little bit of transcript was the judge saying, I don't even want to hear from you. I don't want to hear your explanations, and preventing, that from happening, which is clearly not allowed. That's not fair, right? If the judge is just deciding that you're already guilty and doesn't really care about your explanations. To summarize, there were no circumstances that justified use of the summary procedure. So the summary procedure is basically the trial judge sort of making a really quick call versus basically having a full trial on the contempt. Now, why would we have a summary procedure like that? Well, as mentioned, sometimes you've got somebody in court who is being disruptive or otherwise causing problems. But if it's not something that's urgent, if it's not somebody who's, messing up your court process right away, there's no reason why you can't take time to do it. Especially when we look at this case, right? Because this case, the person had already testified. The trial, so far as I'm, aware, was done. And if it wasn't done, well, at least Mr. Burrell's part of it was done. There's no immediacy here. There's nothing that says we have to get this done today instead of like a month from now, or even 6 months from now. If they did it a year from then, it would still not change anything. There wouldn't be anything sort of urgently requiring this, right? So why not take the time? All right. The appellant, when called as a witness, entered the courtroom, was sworn, and testified. The appellant demonstrated no contemptuous behavior while in the courtroom. The only issue was whether the appellant, by stating earlier in the day that he would not appear in court, was in contempt. This issue was not urgent or imperative to the proceeding itself. Further, the trial judge erred in that he did not afford the appellant any of the procedural guarantees as required, as we've been over. The conviction for contempt was a miscarriage of justice. Now, when an appeals court, usually an appeals court will say something like this was an error or this was a mistake or, something along those lines. To call this a miscarriage of justice is very strong language from the appellate court, and I don't disagree with them. I think that it's called for here. So accordingly, we allow the appeal and quash the conviction for contempt. As the appellant has served his sentence, we stay the proceeding. We also note that on the facts of this case, a prerogative writ may have been available to the parties. So basically, this guy already did the 90 days, which is why they're saying that they stay the proceedings. So they're like, we can't give him that time back. We don't have that ability. That ship has sailed. But what we can do is we can say, listen, there's no point making this guy sit through another, set of hearings and trials and so forth to determine if he should be held in contempt when we've determined that the original finding was done improperly. Now, ordinarily, they might have said, we're going to do another round. You can prove it properly this time. But he already did the 90 days. So the only thing we really can give him at that point is to just say, we're going to stay the proceedings, because even if, they did find that you were in contempt, there's no further punishment to impose. So, yeah, this guy was a little bit cocky, and I will fully yield that, right? When he's going in and the court is saying, well, how about 90 days? And he's like, give her, just go ahead, right? Like, I don't care. I suspect that's because he just missed this exam, right? As I mentioned, these exams can be a big deal, especially if you are somebody who's actively trying in custody to engage in some rehabilitation, right? If you're saying, listen, I'm here because, maybe I don't have my high school diploma, I've got no tickets, I've got nothing to really allow me to work. Improving that might mean that I need to do less sort of crime stuff. Let's work on that. That's a laudable goal. That's an important goal. That's something that we as citizens should want to see happen. And these courses can be tough to get into. They can, can you imagine you're sitting there, you're in custody. You've got no control over your life. You're trying to do this thing to improve your scenario, your situation there. And you might lose several months of education just because they blow up your exam. There doesn't tend to be a whole lot of makeup exams and so forth. So he might have been pretty upset by this. Now, some people in the comments might be wondering, what happened to the original person who was charged? What were they charged with? What? I don't know. It's not in the decision. I couldn't find it. So I just ultimately don't know what the original thing was. And it doesn't terribly matter here, right? Anyway, I thought this was a really interesting case because contempt gives a lot of power to the judge and can potentially be a scary power, right? If you've got the judge who can throw you in jail or impose fines or that kind of thing to sort of manage their courtroom, that's concerning, right? We want to see proper limitations on that so that it's not misused. And that's really what this case stands for, is limiting those powers so that they're not misused. So I really appreciate this decision. I think it's a good decision here from what I've seen. Let me know in the comments below what you think. Maybe you don't like Mr. Burles because he was a bit sort of spicy there. But yeah, let me know. Please hit the like button, the share button, the subscribe button. And if you want to see more of these as they're posted, you can hit the notification bell as well. I want to thank my Patreon supporters as well. At the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Mark Haywire, Gerald to the Bailey, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Vicky. Thank you for watching. I hope this has armed you with knowledge. See you next time.